right. Okay. Well, good morning. Hope everybody got rested last night. Let me briefly, before turning to today's topic, recap briefly what we talked about last night. And aside from the question of what it means for a right to be inalienable in the language of the Declaration of Independence, when we talk about constitutional rights with regard to the Bill of Rights, there are three central issues that I hope came through last night. But as I thought about it, I thought I might condense it and just recap it in a more organized fashion. The first, of course, was the question of what any particular or any individual right means. Okay, so what does a particular right that's stated in the Bill of Rights mean? And I mentioned the issue in terms of religion. What counts as religion, for example? If government's supposed to be neutral with regard to religion, what does neutrality consist of? And I talked about some competing elements of that. When is government being neutral to religion? Because again, if you can't provide math books to religious school, well, Christian or Catholic elementary or high schools, middle schools, in order not to favor them, are you thereby being hostile to them? And the court's always said you can neither be favorable toward nor hostile toward religion. So where's that line in between, if in fact there is a line in between? So that's always a difficult issue. I mentioned the issue of speech, right? How speech is both, in the constitutional sense, in terms of the First Amendment, is both more than speech in the ordinary sense because it includes more broadly expression, whether it's dance, music, art, films, things like that. And it's also less than speech in the conventional sense. But because, before pornographic pictures, there was literature that was considered to be quote-unquote obscene. And there are all sorts of early obscenity cases about that. All you're looking at is a book, but the claim was that this language is obscene, and the idea has been that obscenity does not count as speech within the meaning of the First Amendment. I mentioned also libel and slander. They're a form of speech, but they don't count as speech within the meaning of the First Amendment that's protected. And there's some other areas as well. For example, what is... mentioned the thermal imaging machine. What is an unreasonable search and seizure? I mean, for the longest time, the argument was that, without a warrant or being in a hot pursuit with probable cause, you can't enter someone's home. And an issue came up early with wiretapping. And at the time, the technology was so crude, you'd have to insert a little prong with a microphone into somebody's wall. Well, that counted as entering the person's domicile, right? And since the Katz case, U.S. v. Katz in 1967, the courts basically said that you have what's protected is areas where you have a reasonable expectation of privacy. A reasonable expectation of privacy. So that's, of course, at the peak in your home. It's less so in a phone booth, to the extent that there's still phone booths anymore. It's less so standing out here in the middle of the street. So again, that always gets litigated. If you look at the Fifth Amendment, again, particular issues, double jeopardy. You can't be tried twice for the same crime. That's not as controversial anymore, but how many of you remember the Rodney King case? That was the question of the assault of police officers captured in video. Some say the whole video tells a different story. Others say no, it doesn't. But the police officers were charged, and this is partly the fact that, again, that we have 51 separate legal systems, 50 state legal systems and one federal legal system. The police were charged in state court with assault and battery on Rodney King. They beat him pretty well. And they were found guilty. So the feds turned around and charged him in federal court. But it wasn't for assault and battery. They charged him with violating his civil rights, which are protected by the 14th Amendment against state infringement. And some people said that's double jeopardy, but the court's always said if you're tried in two different jurisdictions, it's not double jeopardy. The whole purpose of double jeopardy, how many of you have seen Les Mis? You don't want the government to be Inspector Javert because they have infinite resources, maybe not as much as Bill Gates, but they have infinite resources, and you don't want them just to pursue you through every level of your life. They can't win a trial here, they'll try there, they'll try there. That's just as good as being convicted. Your life is not yours anymore. But they said because the officers were tried in state court under assault and battery and found innocent, to try them in federal court under the charge of violating his civil rights, that wasn't double jeopardy. One of the reasons that for that to arise initially was the civil rights protection was in the early 1960s, you could not get a state court in the South to convict people who injured or killed civil rights workers. So Congress passed a statute which said basically that it's against the law to infringe upon or violate someone's civil rights as stated in the U.S. Constitution. So that's some of the controversy about double jeopardy. Again, just another quickie here. Nor shall private property be taken for public use without just compensation. That's the so-called takings clause. Okay? You hear a lot about that with regard to eminent domain. I mean, there's still controversy now. If the government, if you won't sell your property to a developer, can the government come along and take it, exercise eminent domain, to give it to or sell it to the private developer on the grounds that the developer will have a more economic use for it, provide greater tax revenue to the state or to the city? That's very controversial. The takings clause is used quite often by conservative anti-environmentalist groups because they want to claim that, if you've got beachfront property but you can't develop it because of some particular creature will be endangered, conservative groups want to say that's a taking and so you have to receive just compensation. Well, if that were the case, that would completely upend all environmental laws because there's no way the federal government has the money to provide these people with just compensation in that sense. There is a case from the late 19th century to say that kind of regulation is not a taking. So that's something that's disputed. Sixth Amendment, what counts as a speedy trial? How long do you sit in the slammer without being tried? What counts as a speedy trial? You have to be confronted with witnesses against him. There's always the issue of when children testify. And can children testify behind a screen so their identities aren't seen? And some people argue that's a violation of your right to confront your witnesses against you. The eighth is, of course, cruel and unusual punishment. Is the death penalty cruel and unusual punishment? Right? Is sentencing somebody to life with no hope of ever getting out, is that cruel and unusual punishment? See, so you can raise all sorts of issues like that with your students, I think. There's an issue with regard to how you go about interpreting all of these things. I'll just mention that they're two awful terms. The question is, how do you understand terms like cruel and unusual punishment or free speech or things like that? One view is called originalism. Originalism. And the second term is even worse. Originalism. It's the idea that the term means what it meant to those who wrote and ratified the relevant provision. So in that sense, you'd say, what is cruel and unusual punishment? Well, it's not what we think it is nowadays. It's what people in 1791, when this went into effect, thought of cruel and unusual punishment. Even Justice Scalia, who said he was an originalist, said he was a faint-hearted originalist because, technically speaking, flogging was allowed then. And he agrees that wouldn't be allowed now, even though, strictly speaking, that was not considered cruel and unusual punishment back then. Okay? The other view, the awful term, is non-originalism. Non-originalism. So that means the Constitution means what we understand it to be today. Okay? And this runs throughout all aspects of looking at the Constitution. The reason I mention that, I thought of it last night and I thought, no, that's too much for us to deal with. But if you look at the Seventh Amendment there, I always pick this particular one. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Okay? That seems pretty clear. What's $20? But I asked an economist friend of mine at Drake, what in $20 in 1791, how much is that worth now? And he said something like $734, as best as they can figure. Right? In other words, the purchasing power of $20 then would be over $700 now. So what's $20? right? Or if you look at the Second Amendment, in originalist terms, it would actually, $20, as stated here, would actually mean 700 some odd dollars. Okay, why did I lose control of this screen? Or if you look at the Second Amendment, with all of its controversy, but look at the phrase, leaving aside the first part, the right of the people to keep and bear arms shall not be infringed. Okay? Well, again, if you think in terms of what was in the minds of the people who wrote and ratified that, they were talking muskets and pistols, right? They weren't talking AK-47s or AR-15s or missile launchers. So, do you get to have your assault rifle? Everybody says, yeah, but strictly speaking, they didn't have that in mind back then. So that's one of the central controversies in constitutional interpretation, originalism versus non-originalism. So again, that first problem is, what does any particular right that's stated here mean? Okay? And again, you can have all sorts of fun with your students with those. The second central problem I tried to suggest last night was the question of whether there are implied rights. Whether there are implied rights. In other words, they're not stated in the black letter text, but they're still there. And I mentioned that sort of mirrors the question about whether there are implied powers of Congress, and I raised the issue of the Air Force. Okay? But on this side, for example, I'll ask students when we raise this question, every course, I don't know if you all do it in high school, but of course in college we always give them a syllabus, and you remember from your old college days, and we put down various policies and procedures. And there's something I put on every syllabus except when I'm teaching my con law seminar. I don't put it on that for the following reason. I ask students in the con law seminar, do you have a right to cheat in this course? Every other course, the syllabus says cheating and plagiarism, other forms of academic dishonesty are strictly forbidden. Any incident results in immediate failure for the course and so forth. I don't put that in the con law syllabus. And so I can ask them, it's not in the black letter text. Do you have a right to cheat in this course? And of course, they're just immediately startled by that kind of question, but they struggle to try to say why they're not, because they all agree they're not. And my point is, you make certain inferences from the nature of the academic enterprise, or I've got one line say you must successfully complete all written work, and they said that implies that you do so fairly without cheating. And so they're engaging in this sort of drawing inferences from the black letter text to say there's certain things you may or may not do, even though they're not stated in the black letter text. So you could try out asking your students, if you don't have it listed to forbid cheating, do they have a right to cheat? But the standard case I mentioned to students, I'll say, is what's the fundamental principle of our criminal justice system? How would you answer that? What's the fundamental principle of our criminal justice system? You're innocent until proven guilty. I dare you to find that in the black letter text of the Constitution. Does that mean it's not there? Or, in fact, are there certain implied features, unwritten features, if you will, of the Constitution? Now, one of the reasons for writing these down and spelling it out like that is to say, write it down so we know what we've got. And the argument about that, in favor of that, is if it's written down, you can point to it. If it's not, you're on somewhat squishier ground. But still, and Justice Marshall would have said to you, Chief Justice Marshall, you can't put everything into a Constitution. Okay, he's got a famous phrase in McCulloch, I think, that to treat it as such would give it the prolixity of a legal code or municipal code, I think he said. And I always tell my students, that's what we pay lawyers for, to read all that stuff. If you think of a city code or something like that, it's just volumes of detailed stuff in lawyerly language, right? You can't put that in the Constitution. It's a statement of general principles. So if you say that there are implied rights, and again, most people agree at some level there are, but the question is how narrowly do you construe that or how broadly do you construe that? The idea of implied rights. And I said that, for example, again, the right to privacy is not written there in the black letter text. Okay. Again, it was articulated prior to Griswold, but Griswold versus Connecticut in 1965, that was the Connecticut birth control case. Okay. People familiar with that case? Is that a nod yes, more or less? Okay. Connecticut had a statute, very Catholic state, forbidding married couples to use contraception. Why they specify married couples? Because technically speaking then, it was illegal for non-married people to have sexual relations. So they didn't even worry about that. So it said married couples may not use contraceptive devices. And the court decided 7-2 that this is, in the phrase of Justice Stewart, this is an uncommonly silly law. Right? But Stewart was a dissenter, along with Justice Black. Black said, I like my privacy as much as the next man, but I don't see anything in the Constitution that forbids the legislature of Connecticut for doing something I see as foolish. You know, it's not, foolish doesn't mean unconstitutional. Right? But the majority said, surely, you can't think, and Justice Douglas wrote the opinion, it was an awful opinion in terms of how he wrote it. And he was sort of renowned womanizer himself. But he said, you can't imagine the state coming in and sort of ripping back the covers in the bedroom saying, okay, are you using anything? Right? You know, that's the sort of horrific situation he said that this kind of law would lead to. And he said it violates the privacy of the marital bedchamber and the marriage institution itself. So it wasn't written anywhere, but they deduced from the very idea of being a free person in a free society that you have certain rights to make your own decisions. Remember that question I put up there, who decides, the majority or the individual, independently of what the majority may require. So the right to privacy is what anchors the notion, again, of abortion, of gay rights, and gay marriage, and all these sorts of things. So it was the real, for people who, cultural conservatives who oppose it, it was the real worm in the apple. Okay? But that's considered an implied right. Okay? So again, the Ninth Amendment we saw last night was put in there to suggest that we're not limited by the rights stated in the written text, the black letter text, but Judge Bork, who's gone now, he's a famous critic of this, once famously said the Ninth Amendment is simply an ink blot. Look like a Rorschach test. You read into it whatever you want. But on the other hand, if you go back to Chief Justice Marshall, you say one of the central principles of constitutional interpretation is that you have to treat anything in there as intended to be. I always tell my students, anytime somebody comes along and says X is in the Constitution or X is not in the Constitution, hold on to your intellectual wallet because somebody's trying to pick your pocket. So that's always a very loaded phrase, whether something is in the Constitution or not. What counts as in the Constitution? What's written in the black letter text, and I suggested, even with black letter text, we have disputes over what counts as free exercise of religion, what counts as freedom of speech, and so forth, or freedom of the press. Okay? So those are the first two main points last night. And the final one, which is what led to all this, was this idea, again, that when, as your book does, and when it talks about individual rights, it focuses on the Bill of Rights. But as I said, according to the Barron v. Baltimore case from 1833, technically speaking, the Bill of Rights does not protect you against your own state government. Okay? It protects you against certain actions on the part of the federal government. Before the 14th Amendment, the only thing that protected you against certain actions of your own state government, whatever was in your own state Bill of Rights. Okay? But what the 14th Amendment, as we saw toward the end last night, did with this, no state shall do this, no state shall do that, no state shall do that. It stuck the federal government's nose in between the individual and the individual state government. Right? So, again, here's the individual, here's your own state government. As I said, Article 4 protects you as an Iowan while you're in another state at some level. And the Bill of Rights protects you against the federal government. But the 14th Amendment says that you have, in metaphorical terms, this basket of rights by virtue of your citizenship as an American that regulate the extent to which, if any at all, the states may infringe upon these individual rights. And the problem was, as I said, was twofold there. Where do we anchor that basket? Where do we find textual support for the existence of that basket of rights? I said the most obvious place was the Privileges or Immunities Clause of the 14th Amendment, but that the Slaughterhouse cases basically eviscerated that. The majority said, yeah, you have certain rights as a U.S. citizen, but there aren't many of them. What we consider fundamental rights are in the hands of the states. That was the majority holding in Slaughterhouse, which eviscerated the Privileges or Immunities Clause. But the dissenters, as I said, lost the war in Slaughterhouse, but they lost the battle, but they won the war, which is to say, no, what the 14th Amendment does is you have these fundamental rights as a matter of U.S. citizenship, not simply state citizenship. So what the court did, as awkward as the language is they anchored it in the Due Process Clause. They anchored it in the Due Process Clause. But the second question, and the more ongoing question in that regard, as I said last night toward the end, was simply, it's fine to say we have this basket of rights guaranteed to us by the federal Constitution by virtue of our U.S. citizenship that protect us against certain actions of the states, but how do we know what's in the basket? How do we know what rights are there? And one view has been that of Justice Black, which was saying that the purpose of the 14th Amendment was in effect to overrule Barron. It was to say, no, the Bill of Rights does protect you against actions of your own state government. So any acts of the federal government that are forbidden by the Bill of Rights are now forbidden to the states. The states are prohibited for doing because of the Bill of Rights. That was Justice Black's view. But that was never a majority view on the court. And the majority view was always, in terms of Justice Frankfurter, his phrase was that the Due Process Clause had an independent potency in his wording. An independent potency. In other words, due process in principle means something independent of what the particular protections of the Bill of Rights mean. Now, there may be areas of overlap, but in principle, they're not the same thing. Justice Black said they are the same thing. But the majority of the court has said that they're in principle not the same thing, but I said that over time, those circles, those domains have become coterminous until almost everything protected for the individual against the federal government by the Bill of Rights is now protected for the individual by the Due Process Clause of the 14th Amendment against the state government. So when you talk about these individual rights that are protected as a matter of being a citizen, and you tell your students, again, if you let them think that, oh yeah, the Bill of Rights tells me the state of Iowa can't do this, that's strictly speaking not accurate. It's only insofar as the 14th Amendment incorporates those protections in the Bill of Rights and makes them applicable against the states. And that's why, as I said last night, you'll see in briefs and in opinions, they'll say, well, the state can't require that we engage in school prayer. Why? Because of the First and 14th Amendment. Or the state can't exercise prior restraint in a speech case. Why? Because of the First and 14th Amendment. So on that point of view, it's the protection we see stated in some way in the First Amendment, but what makes it active and usable against the states on this terminology is the 14th Amendment. So, questions. That's sort of the recap of where we left off last night. Questions or thoughts about that? One of the things to bear in mind, I don't know if you actually would have students ever reading Supreme Court cases or not. I mean, my college students struggle with them at first. And I say, as time goes on, they become a little easier to read, not just because you get away from some of the older language, but just you get a sense of what it is they're doing there. But I'll say that you have to remember that most issues wouldn't get to the Supreme Court if there were an easy answer. Okay? And I had a student once in my early years at Drake, bright student, and she took an honors course from me called Law, Interpretation, and Social Theory. So it really wasn't case-based, although we read one or two. We read a lot of legal theory and constitutional theory. And she got quieter and quieter as the semester went on, and did well in the course, but she got quieter and quieter. And then I didn't see her. She was majoring in math and political science with an eye for law school. And I didn't see her for a semester. And then I bumped into her and said, "Where have you been?" And she was a little embarrassed. She said, "Well, I'm not a poli-sci major anymore." And I said, "Well, that's all right. I've done that to people." I said, "Why not?" She said, "Well, I'm not going to go to law school." I said, "That's fine. There are too many lawyers." And I said, "What are you majoring in now?" And she said, "Math and actuarial science." And I said, "Ac-sci?" And there are two jokes I always hear from people in the business school about Acc-Sci majors and accounting majors. The first is that Acc-Sci majors are people that don't have the personalities to be accountants. And the second is, and I can't remember which is which, an Acc-Sci major will look at your shoes when he's talking to you, and an accounting major will look at his own shoes when he's talking to you. But in any case, I said to her, why? And she said, you remember that course just described me? I said, sure. And she said, well, I would hear somebody take an issue and argue it this way. And it would sound really persuasive and plausible to me. But somebody else would then take that same issue and argue it this way. And that sounded very persuasive and plausible to me. And she said, I can't deal with that. I need right answers. And I said, but in math, at a certain level, there aren't right answers. She said, I don't care. I'm not at that level. I mean, and she was not a person of low intelligence, not at all. Very bright. Went on to a wonderful career at one of the major insurers here in town. And I still see her, and she's great. But she just couldn't deal with the thought that you can argue something both ways. Okay? Who was it? John, do you remember somebody famously said a lawyer is someone who has the capacity to hold two contradictory thoughts in his head at the same time? I can't remember who that was, but somebody made that statement. Or there's this legendary story about Lincoln, supposedly. Lincoln, of course, started off as a country lawyer, and he argued a case in the morning before a judge, and he won that case. And coincidentally, double coincidentally, he had the same judge for a case in the afternoon, and the case involved the same issue, but he was on the other side. And the judge said to him in the afternoon, Mr. Lincoln, didn't you just argue the opposite position in the morning? He said, yes, Your Honor, but I was wrong then. See, but the case had already been decided. Judge couldn't do anything about it. Okay? So, in any case, if your students sort of want simply a right answer in the way you know what the square root of 4 is, you know plus or minus 2, and you know what 2 plus 2 is 4 is, and so forth, that's not what you're going to get here. It's a question, and I always tell my students, just because there's no obviously right or wrong answer doesn't mean there are better and worse, that there are not better and worse answers. And that's what you have to work with. As I said, my students, when I talked about the evisceration of the Privileges and Immunities Clause, that would have given coherence to the way we talk about individual rights protected by the 14th Amendment, they say constantly, why can't we go back and overturn that? It would clear things up so much. But we can't. So again, any other thoughts or questions about this individual rights unit 5, at least as the way I've discussed it?
That question is a little off to the side. Is there a source out there? Because just before I came down here, my students were talking about time and research that's there going on. Is there a source out there that talks about what types of amendments Congress was debating and if debating Bill of Rights before Lincoln was the first time on 12?
Yeah, I can't think of the name of one. You can certainly Google, what were the original proposed constitutional amendments? Google something like that. Remember I said that of all the ones they were talking about, and I couldn't tell you what all they were, there were 12 that actually got through Congress and were sent to the states. And there were the first 10 that were obvious. The 27th Amendment is actually one of the other 2 that didn't pass then. And then there's that one on ratio between number of constituents and a representative, how many people a member of the House represents. But as far as the others, I don't recall, but you can Google that pretty easily. I can't think of any particular one. Yeah, I mean, that's always an issue. There's the issue in that regard. Again, it's a little off, but that's all right. There was concern of whether we can amend the Constitution in just any way we want. And the concern arose particularly in the 1990s, and the question was posed with the following odd phrase: Is there such a thing as an unconstitutional constitutional amendment? And remember, every constitutional amendment we've had went through the state amending process, state ratification process. Anyone would have to, but everyone was proposed in Congress, passed each house by a 2/3 majority. The president has no role there. And there was always this issue of whether we should adopt a balanced budget amendment to the federal constitution. They say, well, the states have them, and there are arguments pro and con. And I think one of the states ratified this amendment. Actually, it was calling for a convention, and it got us, because there are 2 ways of proposing an amendment. Either the proposal passes with a 2/3 vote in each house of Congress, or two-thirds of the states issue a call to Congress to issue a petition or demand to Congress that they call a national constitutional convention. And a state, I think, took that step, got us closer to that in the 1990s. And there was some concern on the part of some people, and they said, what if we have a national constitutional convention? And they proposed this balanced budget amendment, and then they say, by the way, while we're here, let's strip the First Amendment. Or let's take what's called birthright citizenship out of the 14th Amendment or something like that. And one group said, no, you can't do that. The Constitutional Convention can deal with only the proposed amendments for which it's called, or the proposed set of amendments. The other side said, no, Constitutional Convention, in a sense, is the representatives of the people, we the people in our sovereign capacity. They can do anything they want. And the first group would say, no, you can't do that. There are limits on what they can do. There won't be a runaway convention. And then the other group said, we've had only one constitutional convention, and it was a runaway convention, right? It was called in December of 1786 to propose amendments to the Articles of Confederation. Madison is considered to be the author of the speech that Edmund Randolph read at the beginning of the Philadelphia Convention and said, look, putting it in my words, the articles are broken, they can't be fixed, we've got to throw them out and start from scratch, and we've got a plan. Whereupon immediately a bunch of the delegates said, whoa, we're not authorized to do that, we're out of here. Right? And so a rump of 55 people stayed and met in secret all summer in Constitution Hall. If you've never been there in Philadelphia, I ended up there really because a friend of mine got married after a long time. We were in a hotel right there next to Constitution Hall in the National Constitution Center, and they got a hall of the framers, and these sort of black statues of them standing. I got a picture of me standing with Madison, who was no taller than I am. So it was pretty cool. But 55 guys, and it was guys, met all summer in secret. But by September 17th, when it was signed, I think only 39 of them actually signed the Constitution. Right? Edmund Randolph, who proposed the Virginia Plan, didn't sign it. Okay. So there's this question of whether there's any limit on the kinds of amendments we can actually propose. Other thoughts or questions? Okay. Let's turn then to Unit 6. And there are two main things I'd like to talk about, and you tell me which you'd like me to talk about first. The first topic is this question of citizenship, the importance of citizen engagement, the obligations of being a citizen. And the second is the question of, I think, what the unit calls challenges to American constitutional democracy in the 21st century. So, which one would you like me to talk about first? Do you have a preference? Don't be bashful. Citizenship? Okay. Okay. All right. When we talk about citizenship, let me, sort of bring back. I've got some data to show you that I use in a presentation I give to various folks on the election that's coming up. So you'll see some stuff as I scroll through these PowerPoint things. I won't talk about all of them, but I will get to this eventually. But a couple of presidential cycles ago, I was teaching our introductory course, a section of our introductory course in American government and politics. And as I said, I don't teach that anymore. I don't teach freshmen anymore. But, okay, thanks. And by the timing of the course, there was a presidential election along with the congressional elections and the state level elections in November. And so this was maybe early to mid-October. So I was talking about the elections and parties and things like that, and I noticed eyes glazing a little bit. Not that you've never seen that with students, right? And I stopped and I said, you know, if you haven't been following the election, these are college freshmen, so they're not removed from high school senior, and you don't know much about the issues and the candidates and everything, please don't vote. I mean, that may swing an election and affect my life. I got a little bit more high dutch, and I said, in fact, I said, if the South hadn't delegitimized literacy tests for racist reasons, maybe you should not be allowed to vote and get a voter registration card until you pass a certain test. I said, you can't get your driver's permit until you pass a written test. Why not the same thing with a voting registration card? Now, technically, I guess, when you teach government or civics in high school, that's supposed to function as that. Or some state schools, I know they do it in Texas, you can't graduate unless you got a course in American government and a course in Texas state government. Does Iowa do that, or Iowa State? The state universities here do that? Anybody go there? Okay. So this, of course, got the discussion going, but the question is that, as a citizen, it seems you have two central obligations. One is to have a certain amount of knowledge to keep up with current affairs, if we're going to, this is where we get back to your question, one of your questions about democracy. If you're going to be a citizen of democracy. And the second is you have to participate politically. You have to participate politically. Now, the reason for that, we start with the question of democracy. Okay, now, was Chuck, was it you last night who said that your kids will say, well, this is a democracy? What do they take that to mean?
Well, we were discussing the majority last night, and we always talk about how, yes, we have rule for the majority, but the minority still have rights, and they say, well, yes, that's because we have a democracy.
Mm-hmm. Okay. I mean, in principle, ultimately, and that's that question again, are there unconstitutional constitutional amendments? But, again, does anybody got a pocket copy of the Constitution? It'll be in here. Can I turn this? Sure. Rather than going through. Oh, it's just something to immediate scrutiny. All right, so you got those things in here. Let's see. Okay, let's listen again to Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. I mean, in a sense, the 5th article is really significant. That's the Founding Fathers acknowledging that this isn't a perfect document. Right? Again, you get Constitution worship, founder worship, but if they thought it was a perfect document, they wouldn't have included Article 5. Okay? Or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, and here's the key phrase, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified a certain law. Okay? So, again, if in a sense of a democracy, it's with a supermajority, at least of states, right? 3/4 of the states, they could ratify an amendment. I mean, the 21st Amendment canceled out the 18th Amendment, prohibition, right? We could pass the 28th Amendment that cancels out the First Amendment. And again, with this issue of unconstitutional constitutional amendments, you could say that's done democratically. So ultimately, yeah, we the people can decide that. But if the 5th article says that these will have to be counted as part, what was the phrase? Part and parcel or whatever of the Constitution, would throwing out the First Amendment so fundamentally alter the nature of our Constitution that really it can't be seen as just an amendment. You know, I tell my students there's a difference between revising a paper and deleting everything and starting over. So if we got rid of the First Amendment through a supermajority, would we be fundamentally altering the character of the Constitution? So this amendment doing that couldn't be seen as simply part of the Constitution. It would radically change it. So is there a limit to how far a majority can go, even a supermajority? But in principle, yeah, through a majority, again, you could do the exercise, and if you find some listing of the states by population, you need 38 states to, and that's not to say everybody in the state would support a particular amendment, but find the 38 smallest states by population